this training is going to be focused on your guide as an employer with the new marijuana laws. We are going to go over a lot of what has happened in the past, 10 or so years since we had, um, Prop 201 that was medical marijuana and now Prop 207. Um, there is a lot that we don't know simply because we don't know how this law is going to be interpreted in different situations and different cases. We'll see a lot of that come about over the next year or two, and we'll keep everyone up to date with anything new that we do find. Um, but we're going to go over what we do know, what we recommend definitely, and if you have questions, please just feel free to direct. So we'll go over a brief history of legal marijuana use in the state of Arizona. First, we had Prop 203, sorry, I said 201 earlier, which was the Arizona Medical Marijuana Act in 2010. That's 11 years ago now. And then Prop 207 from this last year of the Smart and Safe Arizona Act, which was obviously recreational marijuana use. Going over the Arizona Medical Marijuana Act, just to start off with what we do know from that law, is obviously that allowed individuals who have a debilitating medical condition to have marijuana for medical purposes. That law did not restrict the employer's right to administer drug tests, which is always important, prohibit marijuana use on its premises, or prohibit employees from using or being under the influence during their work hours. So that was the precedent that was already set with that law from 10 years ago. We've seen that upheld, so we're going to assume with this new law that those are going to be upheld as well. The Arizona's Medical Marijuana Act did have a non-discrimination provision with two exceptions for employers. So essentially, employers were able to continue to have disciplinary action in these two circumstances. Essentially, if allowing an employee with a medical marijuana card would cause the employer to lose monetary or licensing related benefit under federal law or regulations. For example, we see a lot of this with our clients who have contracts with the federal government, whether that be construction contracts or even DOT regulations. Obviously, that's regulated federally and it's not legal federally, so they do have to follow those federal laws, and so on and so forth. If you have a case like that, it will actually make your job a lot easier because you basically get to kind of just say, all right, I'm going to go with the federal law and I'm just going to, go with that and make it absolutely not for any of my employees. And that makes it a lot easier. For those of us who don't have that luxury, it is a little bit more complicated to ensure that you're not being discriminatory in any way. Now, the other provision that was made in the Medical Marijuana Act was against an employee who used, possessed, or was impaired by marijuana at work or during work hours. And now, obviously, that can be quite difficult to prove. And we're going to go over the ins and outs of that as we go forward. So in the Medical Marijuana Act, there was no definition of the word impaired. And so that did create issues for the first few years after that law was passed. Thought I was going to sneeze, sorry. Which is why they ended up a couple of years later enacting Bill HB 2541, which was essentially an amendment to that original Medical Marijuana Act. So this revised a few statutes in that law. So in regards to impairment, it essentially states that actions based on the employer's good faith belief that an employee had an impairment while working while on the employer's premises or during hours of employment. Good faith belief, that phrase relieves a lot of the burden of proof off of the employer to essentially be required to prove that that's what was happening, that they were impaired. So that's good news for us. Yeah, so didn't require employers to actually prove. They did define impairment to be symptoms that a prospective employee or employee while working may be under the influence of drugs or alcohol that may decrease or lessen the employee's performance or of the duties or tasks of the employee's job position. So essentially, a decrease or lessen of performance was the main thing there. And then signs and symptoms that indicate impairment. This is not an exhaustive list. It obviously is a very long one. There are a lot of things on here that could indicate impairment. Speech, coordination, actions, demeanor, behavior, disregard for workplace safety, which obviously for our department is, the one of the most important things that we focus on. Involvement in an accident causing damage or injury, and any other symptoms that may be reasonable suspicion of the use of drugs and alcohol. And we'll go a little bit more in depth of that later on. So the Bill HB 2541 did clarify a lot of things for us with that original MMA. And so we're just now assuming that a lot of that is going to carry over now into legal adult use of marijuana. And we'll see how that plays out over the next few years. Okay, so this is one of the most important pieces of that amendment that came about for employers specifically. It created a new defense for employers to exclude employees who had a medical marijuana card from safety sensitive positions. Now we're going to, as of now, assume that this is going to hold with recreational use of marijuana for those same safety sensitive positions. Now, in order to classify a position as safety sensitive, you would obviously have to have very specific drug testing policies, and you do have to indicate either in the job description, whether that's private or public, or somewhere in your official company documentation that that position is safety sensitive. Okay. Any other questions with that? We'll go over safety sensitive a little bit more in depth in a couple of slides. Okay, so now going into Prop 207, we'll go over the basics. I'm sure a lot of you know a lot already about the proposition. The law is actually not very long, or the bill, I should say. It is not very long. It's very well organized, actually. So if you're curious about anything specific, please feel free to just, go read it. It's really not that bad. It does not put you to sleep instantaneously. So if you're curious, there's a lot of information in there. But summary, it was essentially the legalization of recreational marijuana by adults 21 years of age or older, very similar to alcohol. You can have possession up to 1 ounce, home cultivation for up to 6 plants per adult or 12 plants per household. So, if you have 10 adults in a house, you can't just have 60 plants. Public use is prohibited, and there is zero tolerance of driving, flying, or boating impaired. Again, very similar to alcohol. And the effective date, so I should actually update this. The effective date, previously when I made this was still in 2020, at the end of 2020. So we did not have a real effective date. There was no date actually implemented as far as the law goes. Essentially what has happened is for a period of time, there were no, there wasn't any legal retail of marijuana to the general public without a medical marijuana card for, a few months, because obviously the stores had to go through an application process to be able to hold that licensure. And that has since already started. There are depositories and everything that do have that license to sell recreationally. So we can see that now, that obviously people have it legally, and so they're using it. So as long as they're 21 years old, they could very well have recreational marijuana in their possession. All right, so a few more details here. So the Prop 207 does not restrict the right of employers to have a drug and alcohol policy or maintain a drug-free workplace. Um, and so it does try to protect employers there. We'll see how, lawyers decide to interpret that in court later. So far, I have not seen any cases come up on my radar. Um, but if you know of any, please let me know. It does not require an employer to allow or accommodate the use, consumption, possession, transfer, display, transportation, sale, or cultivation of marijuana in a place of employment. Pretty standard stuff. So one important thing from the bill that does affect employers is that the odor of marijuana or burnt marijuana does not by itself constitute reasonable articulable suspicion of a crime. Okay, so um, one of the biggest things going forward with obviously dealing with employees who are, potentially using marijuana, you, um, unless they're impaired at work, you probably won't know if they're using or not unless you have a drug test, like a random drug test that it shows up positive. However, if they're impaired at work or you're worried that they might be impaired at work, you cannot use odor as the only symptom or sign that they are impaired. You would have to um, accompany that with some other sign or symptom. So, for example, um, they smell of marijuana, but they also have bloodshot eyes and are very, confused and they're not working very efficiently. Those things all together, you can use that as reasonable suspicion and you can go send them to be drug tested and XYZ. Um, but for example, I can think of a million different cases where somebody could very likely smell like marijuana and not be under the influence whatsoever. So that by itself cannot be your only sign that they are using. Okay. So in your documentation, just make sure that you make that very clear. Okay, so we'll go a little bit more into safety sensitive positions here. Okay, so for any position to be safety sensitive, even the ones that are specifically written down in that bill HB 2541, the employer or the company does have to designate it as such somewhere in your business records, in your official business records. Um, in your job descriptions would be probably the best place to put it. But even if that's not the case, it does need to be listed somewhere. Okay, so here are a few examples from Bill HB 2541. You can read them. I'm not going to go through all of them, but you can see that you can kind of classify pretty much anything as safety sensitive under your own discretion. So anyone who operates, repairs, or maintains machinery, works in a residential or commercial premises of a customer, supplier, or vendor, prepares or handles food and medicine. There's a lot of things you can pretty much rope in everything. Okay. So those are the specifics with marijuana. I am going to continue to pull that through the rest of the presentation here as far as going specifically into drug testing, your policy, reasonable suspicion in general, and going forward. If you have specific questions related to marijuana, please let me know and we'll go over those at the end as well. Okay, so getting into drug testing. So within the terms of your written policy, the employer may require drug testing consistent with, maintaining productivity, safety, or quality as a part of an accident or employee impairment investigation and on reasonable suspicion of drug or alcohol use. Obviously, pre-employment, random drug testing, those are all good as long as it's in your written policy. Quick note on and drug testing as a result of an accident. So investigation with an accident, whether it is an accident that deals with only property damage or an actual injury, it doesn't matter which one it is. But especially considering employee injury, OSHA, since they do tend to get involved with those, obviously, they can get a little picky with how you drug test your employees following an accident, or an injury, more specifically. They You can get cited by OSHA if you essentially use an accident to kind of start like almost like a little bit of a witch hunt with your drug testing. So my suggestion would be, specifically just being careful with OSHA. If there is an accident, you can test anyone who was directly involved with that accident. So, for example, um, someone's driving a scissor lift or operating a scissor lift on the job, and they damage either the scissor lift or some other materials that you're using, or they injure another employee. You can test that employee who was operating, anyone else who was directly involved, say someone as a spotter or someone else that was assisting with, also on the scissor lift, or, helping with the materials or anything like that. You can test everyone that was directly involved. You cannot, however, just test the whole team, um, including those who were not involved in the incident. That's where you would get in trouble with OSHA. So just a little bit of a differentiation there. Be careful with that. So Arizona's drug testing law, employers must cover all expenses associated with their workplace drug and alcohol testing. Employers must also ensure that samples are collected under reasonable and sanitary conditions. Samples are labeled to avoid misidentification. The person testing is provided the opportunity to disclose relevant information, including, you know, prescription medications and etc. Um, if you are using any kind of third-party facility, they do that. They have a form where they can disclose anything. As far as pre-employment goes, I know that there has been the question of, does the employer have to cover pre-employment drug testing, considering they're not technically an employee? Um, my my recommendation would be to, yes, go ahead and cover it. However, if you're really opposed to that, what you could do, we have another client who they essentially say, if if they get a positive on anything, then they obviously won't be hired and they will pay for their own drug test. If they get a negative, then we'll pay for it, even if we decide not to hire them. And so that way they kind of uh, hopefully discourage people who are actively using drugs from even testing to begin with, and then they don't have to pay for it. And something along those lines. You can decide what's best for your company. I guess it depends on how often you're doing pre-employment drug screening. I would highly recommend it, especially considering, um, you know, the new the new laws and everything with recreational marijuana. But if you have any questions about that, we can chat one-on-one and go through your options. Okay. So employers must also ensure that the collection, storage, and transportation is performed in a manner to prevent contamination or misidentification. Sample testing complies with scientifically accepted methods, and that drug testing does also include a confirmation of any positive drug test. The confirmation does have to use a different chemical process than we used in the initial drug screen. So, just going over all of these. If you guys don't mind in the chat, if you're able to, if you want to just to everyone comment the place that you use to do your drug testing. I know that a lot of people use a lot of different places. Some people like theirs, love theirs. Other people really don't like theirs for whatever reason. So if you want to just go ahead and comment those there, then we have more places to recommend to people. Does If there's anyone that does your own drug testing, I know there are some companies that essentially just buy like the urine kits off of Amazon or wherever, that you can do it yourself, and they do their drug testing that way. Um, I would not recommend that, simply because there as I've listed out here, there are a lot of requirements for employers to follow that do make it very difficult and can open you up to some vulnerability with your drug testing process. So I would not recommend doing it yourself. I would recommend letting a third party do it. But if you do if you do it yourself and you want to continue doing that, um, just shoot us an email after and we can help go through all of the requirements so that we can make sure that you're not opening yourself up for any kind of liability with that. Okay. All right. One person said MBI. I know there's a lot of different places. Concentra, there's the AIM clinic, there's different labs that you can use. So, all right, going over drug and alcohol policy. So the written policy is honestly going to be the biggest key piece here as far as protecting yourself with medical marijuana. Your policy also can offer a lot of flexibility to your company if you need it. Um, you can go a lot of different ways with your policy. I'll go over a lot of different options with you. And if you want to talk about what specifically would be best for your company, we can go over that one-on-one. Okay, so to comply with the drug testing law, an employer must first establish a detailed written policy and distribute it to all employees. Um, and it must include all testing methods, all disciplinary actions that can be carried out, and so at a minimum, the policy must also include a statement of the employer's policy, a description of the employees or prospective employees who are subject to testing, circumstances under which testing may be required. So, for example, pre-employment, random, and reasonable suspicion, things like that, or even on an annual basis, however you decide to do it. A list of the substances that may be tested for. Continues here. A description of the testing methods and collection procedures. Okay, so a little bit more in depth on that. I know most people only do urine testing for drug and alcohol use. Um, with recreational marijuana, not recreational marijuana, any marijuana can show up in urine for up to 30 days after use. So, if you are trying to prove impairment on the job, a urine test is not going to help you with that. If you want to be able to prove impairment on the job, you will need to do a blood draw. A blood draw will show that they either do or do not have THC in their bloodstream. And that will work its way out of the bloodstream within a little more than 24 hours. So, 24 to 48 hours. So, depending on what your policy says, if you need to be able to prove impairment, then you will have to be able to do a blood draw. If you decide to do that, then you need to have that listed as a testing method in your policy and the collection procedures. As far as collection procedures, you can get that from whatever third party that you use. You can just ask them to send you, a brief outline of what the collection procedures are just to put in your policy. It doesn't have to be super extensive, just the bullet points. All right, and if you do use anything other than urine testing or blood testing, I know that some people do even like the cheek swab. I don't know that anyone does hair follicle testing. I think that's a little bit not very many people do that. But if you do use any other method, then you do have to have it listed in your policy. You have to also have listed the consequences of a refusal. Most people just essentially say that a refusal equals a positive test, and then you follow the disciplinary action with a positive. Any adverse personnel action that may be taken based on procedure or results. So, depending on your company, depending on your policy, you may decide you want to immediately say if there's a positive, then they are fired. That is pretty standard across the board, and that's absolutely fine. However, if you want to be able to exercise flexibility with an employee, then you have to write it into your policy. So, for example, you can write into your policy that upon a positive test result, then first strike is they will be suspended for a week and it cannot return until they have 2 or 3 negative test results. They and then second after that week, if they don't have a negative, then they will be suspended for a month and subject to termination. And then third strike is they are terminated. And then you can also say, we reserve the right to terminate at any time based on, based on the situation, XYZ. But if, but that will give you the flexibility to say, all right, this employee, whatever circumstance, we really don't want to fire them, or we're having a really hard time getting employees right now, so we really don't want to let these people go. So we're going to decide that we're going to give them a week because they say that whatever their circumstances is, they say XYZ thing, so we're going to give them a week without pay. If they bring us back 3 negatives, then we'll keep them. But if you don't have that in your policy, you can't do that. So that's where you may decide that you want to be able to give yourself that flexibility. The right of an employee to obtain written results, obviously, they have that right. You can just establish a process for that. The right of an employee to request an explanation of a positive test result in a confidential setting, and a statement of the employer's policy regarding confidentiality of test results. Obviously, test results should be as confidential as possible. Only those who need to be directly involved in the process should have access to those. Okay, so I know that this presentation is dealing mainly with marijuana. I do want to touch on just a little bit of the opioid epidemic because that will play into a lot of our reasonable suspicion going forward. So a few key points on the opioid epidemic. In 2017 is when President Trump officially declared the opioid crisis a public health emergency. And that declaration has not been removed, so it still is currently a public health emergency. In 2019, the National Safety Council study revealed that the odds of dying from an overdose is more likely than dying in a car accident. I know that cars are a lot safer now, and less people die from car accidents, which is fantastic. But it is still pretty staggering to realize that nationally it is more likely that someone would die of an overdose than a car accident. A study from 1995, which obviously was a long time ago, does suggest that 1 in 12 full-time employees uses prohibited drugs. Marijuana was among that list at that time. And a survey of known drug abusers, 75% admitted to having used drugs while at work. And that's not just being under the influence while at work, it's using drugs at work. So if they are addicted drug abusers, they are very likely to use at work. A chemically dependent employee is less than 75% effective. Of recovering addicts, 58% received their first opioids from a doctor's prescription, and 45% were still receiving their drugs from the doctor at the time they first considered themselves addicted. That is why things have significantly changed with prescriptions of opioids over the last, 4 to 5 years. So it is harder to get a prescription for opioids, and they generally are for smaller amounts, and they don't do refills very often. Of pharmaceutical opioid overdoses in 2016, victims were mostly over 45 of either gender and more commonly had a history of mental health diagnosis or physical health problems. Of illicit opioid overdose victims, they were mostly white males between 25 and 44 years old and with a history of substance abuse. So don't think that just because someone is older or more professional or what have you, that they would never be addicted to opioids. It can honestly happen to anyone at any time because of a lot of different factors. Okay, so we're going to get into reasonable suspicion here. So the reason that I feel very strongly about covering reasonable suspicion in general is that because our focus is safety, we want your employees to be safe. We want, you know, everyone on the team, everyone on the site. And if you're working with GCs or multiple contractors on the same site, you want everyone around you to be safe. Even the public, if you're working, you know, in a public area where there are, you know, just random lay people around, you know, even residential areas, you want to make sure that everyone is safe. And even though marijuana use is very likely going to have a serious uptake in the next, you know, it probably already has, but even more so over the next months and years, um, whether an employee is under the influence of marijuana or they are under the influence of a prescription opioid or under the influence of a combination of some weird random things, including alcohol, regardless of what they're under the influence of, if they are under the influence, they are not safe and they are a risk to themselves and everyone around them. So, because that is our focus, we are going to go over reasonable suspicion for a bunch of different things and go into that a little bit more. Okay, so it is the supervisor's duty to be able to make reasonable suspicion determinations for everyone they supervise. The primary focus is obviously the safety for themselves and the public. And a reasonable suspicion referral should be based on specific, contemporaneous, articulable observations based on the appearance, behavior, speech, or body odor of the person. Um, so, especially with marijuana going forward, if you are going to be disciplining or firing employees based on marijuana use, you need to be documenting any instances where you suspect that they are under the influence or they are using marijuana. Um, you need to document it very carefully. So, um, we'll go over some specifics here. Alcohol abuse symptoms. We obviously have, we know these. We've seen people who are under the influence of alcohol. That one's a pretty easy one. Lack of coordination, restricted pupils, blackout, sleepy condition, slurred speech, dulled mental process. That one's pretty easy. Marijuana is also fairly easy to pick out. Um, it's a tranquilizing and mood altering effect. Uh, as far as you know, the appearance of marijuana, the leaves range from green to light tan, usually broken into small pieces. I know that there's a lot of jokes about people uh, confusing oregano with marijuana, so similar in appearance ish to that. Um, it does have a very pungent aroma. If you know it, you know it. I always say it smells like skunk. That's what it smells like to me. This description here is of sweet alfalfa and incense. So depending on what it's like. Common paraphernalia, you have cigarette papers, small pipes, etc. So actual physical signs and symptoms of marijuana use would be reddened eyes, chronic fatigue, slowed speech, lack of motivation, and obviously the odor. All of these here will go through physical, speech, behavioral, and odor. Well, marijuana is the only one with an odor, so that's the only one that will have that one, but they'll all go through all those. Opiates are obviously, they're referred to as narcotics. They're not technically narcotics, but they do alleviate pain and depress body functions and can cause a strong euphoric feeling. They can be taken as a pill. They can be smoked or injected as well. So signs and symptoms, you have physical fatigue. Again, a lot of these are going to have something to do with the eyes. So a good way to just tell if someone's a little off is just look at their eyes, look how fast they're moving around, look how easily they're focusing on things. They might be, you know, they might have the red sclera, the red whites of their eyes. And their pupils either will be usually either constricted or dilated to an odd amount considering their environment. So that's a pretty easy one. Opiates can also cause nausea or vomiting, mood changes, and so forth. Cocaine energizes the system. Snorting cocaine can be, you know, granular, lumpy powder, and it can be snorted, rubbed on the gums, or injected. The base is a small crystalline rock. and the effects are felt within 7 seconds. It's a very rapid drug. And crack does look also like small rocks and is commonly smoked. So again, signs and symptoms, you have dilated pupils, visual impairment, insomnia, high blood pressure. Formication is pretty unique to cocaine use, or formication is the sensation of bugs crawling on the skin, so they can be itchy. Behavioral, they'll have wide mood swings, paranoia, and very activity that is very typical with addiction. Amphetamines are stimulants. They can be sold in tablets or capsules. They can be a creamy white powder. They can also be taken orally, injected, or snorted, same as cocaine. They, again, dilated pupils, runny or bleeding nose. Anything that's going to be snorted can lead to a runny or bleeding nose, or even like a red nose. Obviously, if you see white powder on their nose, it's a pretty good giveaway. But as far as just, their nose in general, it can be red, irritated, bleeding, raw. And they can be confused, have panic, all those kinds of things. PCP. I am going through these relatively quickly, mostly because that's not the focus of our presentation, and I want to be able to have time at the end. I am going to send this to all of you, so if you want to go through it more slowly, then obviously you'll have the opportunity as well. PCP, I did not know a lot about PCP before I started doing the research and learning a lot about this, but it is a pretty intense drug. So a person with PCP can have very rapid mood changes, and even large doses can lead to a coma-like condition with muscle rigidity and eyes still, half open. With PCP, sudden noises or physical shocks may cause a freakout in which the person has abnormal strength, extremely violent behavior, and an inability to speak or comprehend communication, which can be scary. It can be sold as a liquid or creamy powder. And signs and symptoms, we have, again, dilated pupils, dizziness. Nystagmus is the jerky movement of the eye, and they can have impaired coordination, they can be violent, they can have, obviously poor verbal responses, severe confusion, all of that good stuff. Okay, so with all that in mind, again, I do want to reiterate that being impaired in any way is unsafe, right? So whether that's marijuana or any of those other substances that we just went over, even, the guys going out to lunch and coming back, it's a Friday, so they decided to get a couple beers at lunch and coming back impaired from alcohol use. Whatever the case may be, impaired is unsafe. So I do want to stress to you guys that when talking to your supervisors, the people actually out on the job with your employees, when talking to them about marijuana use, I would encourage you to also reiterate just reasonable suspicion in general. It's not their job or your job to try and guess exactly what your employees may be under the influence of. That's not your job. You don't need to really, it could be a combination of 100 different things. So it's not your job to try and pinpoint exactly what you think it was. Their job is simply just to recognize that they're impaired, that they're unsafe, and to pull them off the job, right? So we're going to go into the reasonable suspicion interview, which would be what would happen prior to sending them to go get drug tested. So some suggestions here are to be confident, diplomatic, polite, and respectfully mindful of the dignity and confidentiality of the employee. They're human beings, especially depending on what they're under the influence of. They may have an addiction problem. And so you want to take care of your company, but you just want to also be respectful. Give them the opportunity to describe and explain the events from their perspective. So again, this is where going into documenting the observations of what led you to suspect that they're impaired is very important. Typically, if you can, you would pull them aside or pull them into a private area. I know that obviously on the job site, you don't always have, a separate room that you can pull them into, but maybe get in the truck, something like that. But just say, hey, for example, hey, Timmy, I've noticed that you're really unfocused, you're not motivated, you're kind of you're really slow today. Um, you're also kind of, you know, just joking around with the guys, your eyes are really red, you smell like marijuana. This is what's going on. I'm going to pull you off today and I'm going to send you to get drug tested, and then give them the opportunity to explain. And maybe they do have an explanation that will factor into your decision making later on. And maybe they just say, maybe they just blow up at you and deny it and move on. I don't know. Um, so another thing, do recommend strongly that you accompany the employee to the collection test site. So again, if you're pulling them off of their job because you think that they're impaired and they need to get tested, don't go put them in the driver's seat of a car to then go essentially be a menace on the road, come up on the public road to drive themselves to a testing site. If you do not have anyone that can go with them, I would recommend just calling an Uber. Anything to not have them be the one behind the wheel, because you don't want to be responsible for anything happening to them or to someone else because they were impaired and you sent them away. Inform the employee that they are being removed from their safety sensitive position. So regardless of what they're under the influence of, regardless of, even if, say Timmy's having a bad night because newborn baby and he can't sleep and he's just not focused because he's not getting any sleep. Whatever the case may be, if you're noticing things, they are not safe. So they need to be pulled off of their position until you can establish that they are going to be safe and can put them back on. So maybe for like the next day or two, arrange some other work that they can do, so that, even if they test negative for everything, that they're not putting anyone else's safety in jeopardy. All right, so we are going to do some polls here. Okay, so there's 8 poll questions. They'll just kind of review and go over everything, and they'll just prompt some discussion here. So if you want to just participate in these, that would be great. So the first one obviously is, what is the objective of a workplace anti-drug and alcohol program as a whole? Isn't it infringing on the private lives of employees? And especially with recreational marijuana, that is absolutely going to be the argument of many people that, hey, I'm not doing it here, I'm doing it at home, that's my private life, and you can't tell me what to do, right? That's going to be a very common argument, I would imagine. All right, so pretty much everyone said, yeah, the primary concern is to protect the safety of employees and the public. That's absolutely right. That's everything that we are about here. Okay, so second one is, can an employee be terminated based on a positive test result? Okay, a little bit more mixed here. So the answers are, perhaps it depends on the employer policy, always, and if we don't need them, they're gone. So it does absolutely depend on your policy, but if your policy says that a positive test result means they're terminated, then you go with always, and it's as simple as that. But you do want to just make sure that you're following your policy, because, for example, if you have a high level manager who ends up with a random drug test and they test positive, but you don't fire them because they're super essential to the company and they're a high level manager, but you fire every single laborer that gets a positive drug test, that's going to open up your company to some vulnerability. So that's where you just want to be consistent with whatever your policy says. Third one here says, why are certain employees being singled out in the anti-drug and alcohol program? And for a lot of companies, they do have just like a very blanket policy that applies to everyone. For other people, you may end up deciding, some of your positions are safety sensitive and others are not. It just depends on the dynamic of your company. So the answers here were, the same applies to everyone. We can decide who to test and when, and safety sensitive positions require more focus for the safety of everyone. So it is that last one. If your policy does apply to everyone, then that's great. Not every policy is going to be like that. For example, the office personnel may not be listed as safety sensitive, but every other position is. And the office personnel are tested annually and everyone else is tested on a random basis. And usually people get tested 2 or 3 times a year. You're not singling those people out. It's just that with their position being safety sensitive, there's more risk for something to go tragically wrong, and so they need to be tested more frequently. And that's where you get into the difference of like carpet versus depends on your policy. A lot of things depend on your policy. Okay, fourth one here. In general, when would an employee be required to undergo a reasonable suspicion drug test? This one's a little tricky. All right, super mixed bag here. So the three answers were pre-employment and random, signs or symptoms of drug use or alcohol misuse, and if there was an accident on their crew. So quite honestly, obviously, all of these are absolutely correct. Technically, the answer is signs or symptoms of drug use or alcohol misuse, just because the question is a reasonable suspicion drug test. An accident would be an indication of a sign of substance abuse. So that's where that kind of loops in. Then pre-employment and random are technically not reasonable suspicion. Those are planned. But all of them are correct. That was a tricky one. All right, fifth here. If an employee is showing signs and symptoms of being under the influence, can the test be done quickly? Awesome. Yep, you all got this one right. I mean, obviously within 24 hours is better than outside of 24 hours, but ideally you would send them as immediately as possible. You don't want to leave someone in a position of potentially putting other people in danger just because you need them to finish something real quick or whatever the case may be. So as immediately as possible, you want to pull them off and get them sent over to be drug tested. Couple more here, 3 more. All right, next one is, what if an employee refuses to take a drug and alcohol test? Nice. Okay, so answers were denial is common, send them home and require a negative before they can come back. They will be fired automatically, or refusal is tantamount to a positive test result and follow your policy. So it is that last one. Again, most of these are follow your policy. It really depends on what your policy says, which I know is not necessarily helpful. But it is true. It's, got to be follow your policy. So, yeah, depending on what your policy says, usually people say that a refusal is equal to a positive, and depending on what the disciplinary action is listed out there, you'll just go with that. And sometimes that is that they'll be fired automatically. All right, second to last one here. Does a supervisor have to inform the employee of their rights and the testing process? All right. Yep. This one was a little bit easier. Yes, they should. Employees should be trained and informed via distribution of the policy before they ever get sent to be drug tested. Most people typically this is in their new hire paperwork. It goes they sign that they acknowledge that they read it and that they have it, and that's basically all that happens. If It's always nice to just have your policy available to them if they do get pulled off and they get sent to get a drug test. Obviously, all the information will be in that policy so they can have it as a reference while they're going through the whole process. And the other thing I was going to say is if you change your policy in any way, you are required to redistribute your policy. Typical recommendation is to distribute it with their paycheck. If you obviously do direct deposit or something like that, then you'll need to find a different way to distribute that policy. But anytime it's updated, you need to redistribute it. So for example, following this training, if you decide that you need to make a few updates and adjustments, go ahead and send it back out. Okay, last one here. All right, it says, what if the employee were taking prescription drugs and had to take a drug test? What happens? All righty, okay. So they will have an opportunity to disclose any medications prior to the test, or they will have to provide proof of the prescription. So they do have an opportunity to disclose any medications prior or any substances that they have used prior to the drug test. That happens with the third party. Um, it's a specific form that they can fill out. Um, Now, if they don't disclose, for example, a prescription and they test positive, then that's when they are subject to um, a harder time. If they disclose it, say for example, they got a prescription for a few days of an opioid because they pulled their back and that's what the doctor gave them. And it's totally through their family medicine and whatnot, has nothing to do with work, but that's what they have. So they're obviously going to test positive. Um, the the ins and outs of that a little bit are just that they're not required to provide proof of the prescription. But again, depending on your policy, you may decide, all right, this is a prescription medication for a personal injury. They're just going to have to, we don't want them working while under the influence of whatever opioid they're taking or whatever. So we're going to have to transition them to a different job for the remainder of the week. And you may even decide that you want to request a negative before you can put them back into full duty. Um, that depends on your company, that depends on your policy, but that would be kind of the standard of how you would deal with that. So now it's just questions and discussion. I will say that I know, I know that this presentation and a lot of the information here does go back to it depends on your policy, it depends on your policy, and there are a lot of different options out there for you. Um, if you want to go over the specifics for your company, please absolutely feel free to reach out to me. I am happy to discuss the ins and outs with you and help you go through, some questions to help you decide what you do want to put into your policy. I'm happy to do that. But now, at least, I hope you guys feel like you have a few different options that you can um, look at to go through your policy with. If anyone has any questions, you can unmute yourself, you can put it through the chat, whatever you're comfortable with.